sir. For the defense?
May it please the court,
Yes, sir.
Madam Solicitor. And members of the jury, the top three of those who were called for jury service. Those of you who sit here listening today are the top 3% of all those called for jury service this week. You may wonder why it took 3 days to take you. I think the solicitor and I have the same idea in mind. We have looked into you, probably more than you would want to be looked into, to find, to assure ourselves that you would be honest, thoughtful, not impulsive, willing to listen, not to judge on what we think was in somebody's mind, but what we know from their actions, what they did, and why they did it. This is a criminal case. This is not a matter of guilt or innocence. You'll get to see the indictment. And that indictment is the menu, if you will, of what the solicitor in the hundreds of experts, investigators, SLED agents, North Charleston police officers, the FBI, and others in 18 months of investigation determine what the charge would be. Only the solicitor has that power. Here's a book, and you'll see it. It's about this thick, that lists the criminal offenses in the state of South Carolina. Out of that book, after studying it with the resources that they have, murder is the charge that the solicitor chose to have in the Murder is the most serious offense in the eyes of the law in the state of South Carolina. It's the same charge that Hillenroof in the Emanuel case is charged with. there's no more serious matter in South Carolina than a criminal offense, murder. So already this morning, that offense has started to erode. In the opening statement, the solicitor, after 18 months of evaluation, still charges him with murder, but starts to set the tone that there may be another charge. This is an extraordinary case. You go around this courtroom, or this courthouse, and I would encourage you to do that. This is our new courthouse. And in this courthouse, we've combined all the type of courts that we have in Charleston County. Well, yesterday, those of you that may have entered one of the civil courts, the small courtroom next to the jury assembly room. And that's a court that decides people who have money issues, that they didn't pay their rent or abide by their contracts. And in that courtroom, there are different rules. And those rules are the same that could be in this courtroom. People have an automobile accident, maybe their doctor mistreated them, or maybe the housing that they live in wasn't constructed properly. That's called civil court, common pleas court. And in those types of courts, under our judicial system, the level of proof, if you close your eyes and you think of Lady Justice, all it needs is a mustard seed of evidence to break that scale. Ever so slightly more evidence one way than the other. And the reason for that, I believe, is because that's all about money. Whether it's debts owed or injuries caused by others, the resolution is money. In the criminal court, the extraordinary court, the criminal court, money's not an issue. Freedom is. So when you try somebody not for their wallet, but you try somebody for their freedom, the standards are different. The burden of proof, remember those words, burden of proof, that is the focus, the prism in which you look at the facts of this case, is beyond a reasonable doubt. And if you close your eyes again, Lady Justice tilts ever so much, not by a mustard seed, but to the extent that you find a reasonable reason, based on your life's experience, doubt as to whether Mr. Slager is guilty, not an issue of innocence, guilty of the charge that the solicitor chose to bring. Talk about that a little further. Civil cases are money cases. Criminal cases are freedom cases. There are other types of cases that are involved. Employment. South Carolina, basically fire anybody for any reason you want. Very little evidence for that. This is not that type of case. This is a case involving a criminal offense governed by a presumption of innocence. Unlike anything that you've seen coming in here, at this moment, and the court will tell you, at this moment, and until you find otherwise, Mr. Slager is presumed, that means the prism at which you look at this case, he is presumed to be innocent. Innocence in this sense, the sense that the court has told you guilty or innocence, is not your common experience of innocence. Innocence in this context means not guilty. So what am I talking about? Well, you can have issues in your life where it results in findings, such as your job. Are you entitled to keep your job? Are you entitled to keep the money in your wallet? Or, in this case, did your actions mean you have to go to jail? So there's a huge difference in an action and how you categorize it, of whether you can keep your job, you don't keep your job, you don't keep your job because you aren't innocent, in the term that we usually use. You don't keep your money because you're not innocent, in the term we usually use. And then there's a quantum leap to, you go to prison because of that same action. So presumption of innocence means that in 2014, 2015, 2016, the climate of this country and the focus of the media in this country often spoke of incidents of policemen involved in apprehension of suspects that resulted in the death of those suspects. It's on the news all the time. It's also on the news that over 65, 66 law enforcement officials just this year, in the first 10 months of this year, 66 law enforcement officials on the job died as a result of violent behavior. That's the world outside. You can't, I don't expect anybody to erase that from their mind, because that's, we know that, as indicated by your questions the other day, and your answers to those of you that have heard about this case and seen the video of this case. But that 3%, those of you that are here of the 3% or of the 2% have agreed under oath only to hear the evidence in this court and to base your decision on what the judge says is allowable for your consideration. April 4th was a Saturday. It was Easter Saturday. And Michael Slager, a 5-year veteran of the Coast Guard, a 5-year veteran of the North Charleston Police Department, 4.5 years of which he worked the midnight shift as a patrol officer. And you'll hear evidence what a patrol officer is. That's the first line of security in the community. Not the special squads, not the detectives, not the big shots that say it's illegal all the time. But the guy who's working shift that's out on the street making $43,000 a year. The guy who for 4.5 years got up at hours that we're sleeping and patrolled the neighborhoods of North Charleston. 4.5 years in which he earned a reputation of excellence. Not okay, not marginal, not good, but exceptional excellence in the manner in which he carried out his duties to protect our community. Excellent. 6 months before this tragic incident, Michael Slager, because of his wife being pregnant, and the need to be more available as a father to his 2 other children, requested to be moved to the daytime shift. And that was granted. So from October of 2014 to April 4th of 2015, he worked the day shift. But because of his excellence and reputation, his way he handled his community duties, he was given the most crime-ridden area, the #1 crime-ridden area to patrol in North Charleston. In that area that he was authorized and told to patrol, it takes about 3 minutes to follow the path that he followed multiple times every day. And given the limited resources of the North Charleston Police Department, the management said that this area deserves more than a patrolman. That 3-minute rectangular circle that he patrols every day had 2 patrol officers, meaning that at the worst case condition, when the 2 patrol officers were there, within a minute and a half, the most a minute and a half, there'd be 2 patrol officers available to answer calls, whatever event had happened. Now, that April 4th morning, when Michael Slager woke up at 6 o'clock in the home with his children and his pregnant wife, he got dressed. Sort of similar to what you and I would do every day. Except before he got dressed, he took out his taser that you've heard about this morning, an authorized piece of equipment authorized by the North Charleston Police Department and many other police departments around the country. The purpose was for a limitation of injuries to suspects and to the police officer himself. And you will hear about the use and the proper use and the training of the taser. Much better than a nightclub. Those of you who remember when a police officer would walk down the street twirling a baton, which would crack heads, make permanent injuries, could be used against the officer. Gas, some of you on the jury may have your own personal protection device. Well, gas doesn't particularly work well on a windy day because it comes back at you or dissipates. So he was given by the North Charleston Police Department a taser for the sole purpose of limiting physical harm to suspects or himself. So when he got up that day, and you'll see the records of this, when he got up that day, as part of his getting ready for work, he tested it to make sure it was functioning properly. He then, as a first responder, like a fireman, an EMS tech, dressed in a uniform. Purpose of dressing in a uniform is to show that I am a police officer. I'm not just somebody on the street. I have been given authority by the government to enforce the laws of this community. So he put his shirt on. He put his pants on. But he also put on his law enforcement equipment. You'll see somewhere during the trial the 25 pounds worth of protective gear that he wore. Firemen wear protective gear, don't they? So you see them at a fire, they have their hat, they have their coat, they have their boots, protective gear. But they don't wear it in the firehouse. They don't use it until they go to a fire. Law enforcement's different. Law enforcement gets up every day because when that fire, if you will, ignites, they don't get any warning. So the difference here is law enforcement has to wear that protective gear 24/7 at the times they work. 25 pounds. Why? The answer should be obvious. Although they spend 90% of their time or 95% of their time helping people, acting as a social worker, acting as a priest, listening to the disputes, acting as a marriage counselor with people who are on the verge of domestic violence, doing their activities in the community with the children in the schools and all the other good things that law enforcement does. There's always that unknown out there of when things turn from a normal Saturday morning with the sun shining and people preparing for their Easter holiday into a period of violence. That's why they carry that 25 pounds. So he went off to work that day. Kissed his children goodbye. Got in his car that has another series of protective devices and engaged in his activities of bringing peace and preserving peace in the community. While riding on his route, that route that I told you takes 3 minutes to complete, he saw a vehicle that didn't have a brake light. An insignificant time of patrolling, just a nothing out of the ordinary experience. The purpose of stopping that vehicle with the brake light out, it's been insinuated that in some way was punitive. That's not the intention of Mr. Slager. It was not the intention of the North Charleston Police Department. It's not the intention of the law that authorized that. The law says equipment failures, police are authorized to stop that vehicle, not to punish them, but to put them on notice, because they may not realize that their brake light is out. So that when a brake light is used for the purpose of having a brake light, the car, truck behind them may not see that, and it may result in injury. How do we know that? How do we know that Savage isn't just giving you that? Because you can go back in the 5 years in which he was a police officer, and you can look at the stops he made for equipment failures that are documented by the North Charleston Police Department. And you will see that 98% of those times, no one got a ticket. Because remember where the stop was? At the auto parts store. The typical reaction of not just Slager, but the other police in North Charleston on an equipment failure would be, you need to get that dollar out of your pocket, go inside, buy a new bulb, everything will be fine, good luck to you. And that's what would have happened that day, except for the choices made by Walter Scott. Now, all the King's horses and all the King's men from the FBI and SLED and the solicitor know something that I don't know how to figure out. They claim to know what was in Walter Scott's mind. How do they do that? They say that Walter Scott ran that day because he had child support payments due? Really? How long had those support payments been due? You heard he went to work every day. Apparently didn't use any of his income to pay his child support. But
the fact that he wasn't in hiding, I mean, if you thought there was a bench warrant out for you and that you were going to go to jail and that's why you ran, that's pure speculation to fit the narrative that the state wants you to believe. There's no evidence. Yes, he owed $18,000, $19,000 in child support, but you don't owe $18,000, $19,000 child support overnight. That was his lifestyle, making $55,000 a year. He chose not to pay his obligations. But it didn't happen on April 3rd or April 4th. Why did he run? Why did he choose not to respect the request to stay where he was? That's something that I hope you consider when you evaluate the evidence in this case. He didn't just run. He physically and forcefully resisted to the extent that they were both fighting on the ground. And the solicitor with all the king's horses and all the king's men would speculate that the DNA got on the taser because Slager put the taser on Mr. Scott. Because she doesn't want you to believe that Mr. Scott, while fighting on the ground, took the taser away. I think when you see the video and you hear the audio of the video, perhaps you'll have some, not just reason to doubt about that theory, but that you'll find positively some other cause for that. Now, what happened that day? Mr. Slager will tell you it was tragic. Mr. Slager would agree with you that it was awful. The loss of a loved one under these circumstances, under any circumstances, but particularly circumstances of violence, is awful. But in this case, we're not here to decide socially whether it was awful, but we're here to use the criminal court's rules to decide whether or not it was awful but lawful. Not all awful things in this community are unlawful. If anybody thinks that Mr. Slager or any other police officer wakes up in the morning and leaves his family and goes to work with the intent of causing somebody physical harm up to and including death, that's preposterous. You look at the film of the stop as well as the film of Mr. Santana. I challenge you to look for anything said, anything done, the tone of the comments, the actions of Mr. Slager that indicate any animus, any racial animus, any personal animus. Anything but a police officer exercising his instructions and his duties as a police officer in an absolutely unemotional, professional way. I challenge you to look for any evidence that would indicate he was angry, he was ticked off, he was in a resentful mindset towards Mr. Scott? No. Scott ran. The instinct of a police officer, that's when things changed, when Scott ran. Because people run for a reason, and the reasons are only in their mind. He ran before Slager had an opportunity to check the driver's license, check the automobile. And if he had checked the driver's license, he would have found that the FBI and the National Crime Information Center considered Walter Scott.
Objection, Your Honor.
Objection sustained.
He, Mr. Slager, did not know what others knew about Mr. Scott because he hadn't had time to receive the response on his background check of Mr. Scott. Mr. Slager's been indicted. Let's take a look at that indictment. So this is the menu, if you will. This is the meal that's been selected for you. You have no choice in this. This was given to you. So when you don't have a choice in something, the charge against Mr. Slager is murder. Let's turn that over and look at what the solicitor has said back in June of 2015 of what Mr. Slager did on April 4th of that year. So while this trial may last some time, and while you will be here for some time, the truth is, and I know we're all looking at different pictures of this, that in Charleston County, on or about April 4th, well, it's not on or about, it's on April 4th. The morning of April 4th, about 9:30, the defendant, Michael Thomas Slager, doesn't mention that he's a law enforcement officer at the time, with malice aforethought, killed and murdered Walter Lamar Scott by means of shooting him with a handgun, and Walter Lamar Scott did die in Charleston County as a proximate result of on or about April 4th. We agree with that in most parts. So let's take out what we don't agree with malice aforethought. And let's take out murder. And let's take out murder. And let's take out violation of law. So that is the menu that you have been given. Leaving out the facts of the circumstances of a police officer exercising his duties at the time this happened. This is true. There's nothing untruthful at all about this message. We agree that on April 4th, Michael Thomas Slager did kill Walter Scott by means of shooting him with a handgun. It's a fact. It's not disputed. What's disputed is what, first of all, it's incomplete. But second, and most importantly, these words, malice aforethought. Malice aforethought is what makes what we say is awful but lawful killing of Mr. Scott. Malice aforethought changes this from getting fired, paying money, to going to prison. Malice aforethought. Those are the two words that change this from an employment termination, a civil settlement, to prison. What is malice? Malice has been defined in Black's Law Dictionary, which is the lawyer's first year of law school book you're going to carry around in your big shop. The intent without justification or excuse to commit a wrongful act, ill will, depraved heart. You look at everything we have to offer, we being the state of South Carolina, on the video, and particularly the audio, the dispatch information, the video in the car of Mr. Slager, his communications that were recorded by Mr. Santana. I challenge you to find any evidence, even a scintilla of evidence, even less than a mustard seed of evidence, that there was any ill will or depraved heart. You're not going to hear UGDSOB, blah, 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 blah. You'll hear Mr., and you'll hear light tones. You'll hear a warning, taser, taser, taser. You didn't just shoot somebody. And you hear that repeated. And you hear, get on the ground. And you hear instructions which Mr. Scott, for the reasons we don't know, failed to give any indication ever. Okay, I've had enough. I cry on. Let's stop this. The same, all the king's soldiers and all the king's men and a couple of the others involved in the government speculate that Walter Scott was running because of his child support payment. What else was there? They speculate in the sense of today, they say, unarmed Walter Scott. Heard that? Slager doesn't have the same ability that apparently the government has. How would he know that he was unarmed? He never had a chance to pat him down. He never had a chance to frisk him. He could have, if he wanted to, when the car was stopped, tell Mr. Folk to get out of the car and tell Mr. Scott to get out of the car, and he could have patted him down looking for a weapon. It just wasn't that big a deal. It was a brake light. Go in the shop, get a brake light, go on your way. So when Mr. Scott chose to run and act the way he did in running and fighting, and I think most reasonable people, if they heard a taser was coming, hands up, don't shoot. There was no hands up, don't shoot in this case. You'll hear, I believe you'll hear. It's hard to hear, but I believe you'll hear what Mr. Scott had to say. It wasn't Mr. Slager who was angry and full of animosity. You'll have a heavy burden because you don't speak just for yourself, you speak for our community. And I realize that there are a lot of pressures on the members who will make it this jury. It is your sworn oath not to let that influence your decision. It's your sworn oath to decide this case based on the facts and the law that the judge gives you. And I have every bit of confidence that you will do it in a non-impulsive, thoughtful, dispassionate manner, looking for what the state has chosen in this case. The state has chosen to make their burden that this was an act of malice. Malice aforethought, and let me take a look at aforethought. That's the definition of a thought of aforethought. And when you look for the malice, and you look for any premeditated or planned or deliberate act, either when he got up that morning, when he stopped the vehicle during the course of the chase, or even as the fatal shot was fired, I'm convinced that this was not a malicious, deliberate, planned, premeditated act. So the only alternative you've had, based on the choice of law that the solicitor has given you, would be to find Mr. Slager not guilty.